Has a welfare program. Again, it doesn't have to, but it has. It's decided to have one. You've already applied and are receiving welfare, or Social Security, or disability benefits, or what have you. If you're going to be thrown off, you are going to be thrown off by your caseworker. You have a procedural due process right that's implicated because you have a property interest in those payments. Now, sometimes even a government job can count as property, so that if you're fired from your job, you'll have a procedural due process protection. But again, it depends on whether you have an entitlement to continue in the job, as opposed to a mere hope or expectancy that you will. For example, let's say you've been summarily fired from your government job. How do you know whether you have a property interest sufficient to complain in terms of procedural due process? Well, the court decided two cases, Perry versus Sinderman and Board of Regents versus Roth. In Roth, you had a situation where an individual had a contract, a yearly contract with a state university. So, review, you had state action. And at the end of the contract, he wasn't renewed. And he complained that he wasn't renewed, that he wasn't given any procedures about that non-renewal. He wasn't told why he wasn't renewed, or the basis for the decision, or anything like that. And the court said in that case that he doesn't have any procedural due process rights. He had no property interest in the job, because there was nothing in state law, in any contract he had, in the policies of the state, any mutual agreements running between him and the state, that showed in any way that the state had committed itself to allowing him to keep his job. And the court said to find out if you have an entitlement to keep your job except for good cause shown, we look to state law. We look to the positive attributes of state law to see whether the state has committed itself to giving you this entitlement. And since all he had was a contract that expired of its own terms, he had no entitlement, he had no property interest that counted, he had no rights to procedural due process. Contrast that with Perry versus Sinderman. Looked like a similar case, but it wasn't. What was similar is that you had a situation who was employed, where an individual was employed by a state university, so we have state action, and he was let go. Now, he didn't have any tenure, and he didn't have any official contract that allowed him to be employed except for good cause shown. But he was able to show, and here's the distinction with Roth, that there were understandings then in existence with the university, embodied in policies adopted by the university in their handbook and that sort of thing, that persons who had been employed at that university satisfactorily for 7 years or more, which he had, would be regarded as having something like de facto tenure. In other words, it operated, and the state committed and agreed that if you had been there for a certain period of time, a certain number of years, and you had been renewed successively, although the school had no formal tenure policy, it in effect recognized a kind of tenure. And therefore, that individual had a property interest because under state law, we could find an entitlement for him to continue in his job except for good cause shown. So the distinction will be what kind of entitlement you can point out or not. If a person is an employee at will, or a provisional employee, or a temporary employee, or something like that, you have no entitlement, and you can be summarily fired without any procedures. On the other hand, if a person has tenure, whether actual or de facto, or if there are state laws that you can interpret to claim an entitlement to continue in your job, if you're described as someone protected by civil service, for example, then your job is a form of property. Now let's assume you do have a property or liberty interest that counts, and you have a deprivation of those interests. The next question is, what processes do? Exactly what procedures do you get because the state has deprived you of a life, liberty, or property interest? In deciding what procedures are due, there's an interesting issue that has arisen where the states have tried to say, look, if you define liberty interests and property interests primarily by looking at state law to see whether they've been created or not, well, just like the state can create these interests, it should be able to say what procedures should accompany the loss of these interests. And in that regard, this argument by the state has been dubbed taking the bitter with the sweet. That is to say, if you accept that you have a property interest under state law by looking at state law, you have to take the sweet part of that with the bitter part. The state can also decide in the same definition of what your property interest is, what procedures you'll be entitled to when the government wants to end that property interest. But the court has rejected this bitter with the sweet approach. It said that, yes, we'll look to state law to see whether a property interest is implicated, but once we decide if it has been or not, it's a matter of constitutional doctrine to be decided by the court what procedures you're actually entitled to. Okay, what procedures are you, as a matter of constitutional law, entitled to? Well, generally speaking, the rule is, absent some emergency circumstances, some exigent circumstances, minimal due process requires that you have notice and an opportunity to be heard, and that you be heard by an impartial decision maker. And ordinarily, the opportunity to be heard should come before the deprivation that you might suffer. However, beyond this general statement, the court says that it will determine actual procedures in any given case by weighing three factors. These are the three factors that arose in the case of Matthews versus Eldridge. First, we'll look and compare and weigh the nature of the private interest that will be affected by the official action. Second, we'll weigh the risk of an erroneous loss of the individual's interest and the value that additional procedures will give in terms of accuracy. And finally, we'll look at the government's interest and the burden additional procedures will place upon the government. Now, we might as well confess right up front, there's no way to predict how this balancing of factors test will come out. A lot of scholars have complained that this test is ad hoc, it doesn't give clear guidance, and that's true. And probably the best way to think about applying the test is to just consider how it's been applied in particular cases to get a flavor for what the court has done with the balancing test. Take the case of Goldberg versus Kelly itself involving welfare benefits. The state gave some procedures before you were terminated, but they were minimal. You were terminated first by a caseworker, and then, after the fact, you were allowed to write into the bureaucracy and say why you thought that was wrong. Were those procedures sufficient? The court held they were not. Indeed, it held that in the welfare context, you needed a full administrative hearing before termination. Weighing the factors of Matthews versus Eldridge, first, what's the nature of the private interest here? Well, it's welfare benefits, the very means of survival, the court said. Very, very important. And so the court was going to be very interested in looking closely to see that it had procedures that accurately applied the law and gave a person a fair chance to see that the law was being applied accurately. Second, what about the risk of erroneous determinations, mistakes under the procedures that the state had in place? Well, the risk was very high, the court said, because after all, welfare beneficiaries usually aren't so sophisticated that they can, after the fact, write in and explain their situation. They should be able to confront the people who are saying that they are no longer eligible. They should be able to explain their circumstances verbally and in person. Finally, what was the government's interest and the burden of imposing additional procedures? Well, the court said the government's interest was money saving. They wanted to get people off the rolls as quickly as possible if they were ineligible. But if they kept them on the rolls and later determined that they were ineligible, they would lose money because these people typically would be judgment-proof, the court said. Weighing all of that, the court said the government's interest in money saving, as against the high risk of error and the important private interest here, the very means of survival to the individual, the court said you had to have better procedures and, as I said, required a full-blown administrative hearing prior to the termination. Now, this contrasts with other cases where the court has said you can have your hearing after the fact. And in terms of looking at the balancing factors, as I said, it's going to be your job simply to go through the balancing factors and do the best you can. I will say, though, that the best argument for the government to have a hearing after the fact is to say, for example, that there was some sort of an emergency or an immediate need for the government to act first and talk about it later. For example, take the case of seizing adulterated drugs or misbranded drugs. Well, there, the state's interest in health and safety may be paramount. And on the balancing test, it should be considered more important. Let the government decide first, let's talk later. Well, that concludes our run-through due process of law. Let's get a new tape and start the equal protection of the laws.